Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal Joon, Associate Editor, latestlaws.com, and I will be taking you through the significant orders and judgments passed by various courts in the country and some important international news from this week. Let's begin with Supreme Court this week. The Supreme Court has issued a series of directives aimed at expediting the resolution of criminal cases against elected members of Parliament and legislative assemblies. The petitioner had also challenged the constitutional validity of Section 8 of the Representation of Peoples Act 1951. The bench led by CJ Chandrachud delivered a landmark judgment addressing the expeditious disposal of criminal cases against elected members of Parliament and legislative assemblies. The court acknowledged the critical importance of ensuring a speedy resolution of such cases to maintain public faith in the democratic process. The court, in its reasoning, emphasized that undue delays in the adjudication process could lead to an erosion of public trust in the political system. The court recognized the need of a comprehensive and uniform mechanism to address systematic issues causing delays in the disposal of cases against elected representatives. The Supreme Court has upheld the conviction and life sentences of appellants involved in a deadly conspiracy related to liquor poisoning. The court, in its judgment, relied on the landmark case of State through Superintendent of Police versus Nalini, establishing the essential elements required to prove a case of criminal conspiracy. The court reiterated the principle that all conspirators are liable for offences committed individually, emphasizing the joint responsibility even if some haven't actively participated in the commission of those offences. The Supreme Court has affirmed the ruling of the Delhi High Court, which held that assistant and personal assistants of the Ordnance Factory Board headquarters are entitled to the same pay scale as their counterparts in the Central Secretariat Services and equivalent post in the Armed Forces Headquarters, Civil Services, Cadre, New Delhi and other similar cadres. The Supreme Court, while presiding over an appeal against Madhya Pradesh High Court judgment, has noted that there has been a pervasive disregard for the guidelines outlined in the 2021 judgment of Rajnesh versus Neha, and accordingly issued a direction for a copy of the judgment containing guidelines for expeditious disposal of cases involving grant of maintenance to be recirculated to judicial officers in all high courts across the country. The Supreme Court underscored the overreaching objective of maintenance proceedings, the welfare of the child. The court highlighted the failure of officers to recognize and implement the guidelines, emphasizing the ensuing unnecessary proliferation of disputes to appellate courts. The Supreme Court has issued a series of significant directions pertaining to the recruitment of district judges in various high courts across the country. The matter was brought before the bench of CJ Chandrachud along with Justice J.B. Pardewala and Justice Manoj Mishra. The case revolved around the recruitment of district judges in several high courts in India, particularly those of Madhya Pradesh, Punjab and Haryana. The proceedings were initiated to address various issues related to the recruitment process, timeline and infrastructural challenges faced by these high courts. The Supreme Court, while dealing with the question of evidentiary proof to be presented in a case of sexual harassment at workplace by a government official, has stated that in cases where a defense of false implication of ulterior motives is raised, the courts are obliged to conduct a thorough examination of any evidence to determine the credibility of the allegations, ensuring that genuine claims are distinguished from baseless ones. The test of prejudice represents a well-established legal doctrine applied in cases of procedural irregularities or violations of the rule of odi alterum. It serves to ascertain whether such violation resulted in an actual prejudice or a denial of fair hearing. Now let's have an overview of high courts. While giving relief to Parle Agro on taxability of flavoured milk, the Madras High Court has held that GST Council cannot determine the classification. A single judge bench in its recent ruling has held that flavoured milk would attract GST at the rate of 5%. The GST Council, in its meeting on December 22, 2018, classified flavoured milk under HSN, Harmonized System of Nomenclature Code 2202. Accordingly, it attracted GST at the rate of 12%. Answering the question as to whether it is a beverage containing milk or milk and cream, the court reduced the GST. The Supreme Court quoted its ruling in the case of Mohit Minerals and observed that the recommendations of the GST Council are not binding on the Union and states. The deletion of Article 279B and the inclusion of Article 279(1) by the Constitution Amendment 2016 indicates that the Parliament intended for the recommendations of the GST Council to only have a persuasive value, particularly when interpreted along with the objective of the GST regime to foster cooperative federalism and harmony between the constituent units. The Punjab and Haryana High Court has held that it is a primary responsibility of a state to compensate the victims of incidents involving stray animals and said in a case of dog bite, the financial assistance will be Rs 10,000 per tooth mark. The bench of Justice Vinod S. Bhardwaj gave the ruling after disposing of 193 petitions pertaining to compensation to victims or their family members for accidents caused by stray animals, leading to injuries and deaths. The court also issued guidelines to be followed by police on the receipt of a complaint about any incident or accident reported due to the involvement of animals, stray, wild, pet or deserted. The Delhi High Court has ruled that courts cannot interpret the contract between the parties under Section 34 of the Arbitration and Conciliation Act if the finding of the arbitrator is well reasoned. A division bench, while allowing the restoration of an arbitral award, asserted that the single judge bench acting under Section 34 of the Arbitration and Conciliation Act exceeded the permissible scope by reinterpreting the contractual terms between the parties and substituting the findings of the arbitrator despite the arbitrator's conclusion being plausible and well reasoned. The Bombay High Court has ruled against the reopening of a tax assessment related to the sale of a plot of a real estate company, stating that the reopening was impermissible as it amounted to a change of opinion which is not allowed under the law. The petitioner filed its income tax return declaring income and profits under Section 115 JB of the Income Tax Act 1961. The assessing officer passed an assessment order accepting the declared figures. Subsequently, the AO issued a notice under Section 148 of the Act seeking to reopen the assessment based on an internal audit objection. The Gujarat High Court has dismissed an application for grant of anticipatory bail holding that cheating in competitive examination is required to be dealt strictly. The court observed that when it comes to the competitive test, it is necessary to handle misconduct, misbehavior, malpractices and cheating strictly. The court stated that the purity of the examination is of paramount consideration, and in the competitive examination where many incumbent candidates burn their midnight oil to secure the government job and are eagerly waiting for the government job, they are ultimately deprived due to such unscrupulous elements and their dishonest activity and malpractices. Bail cannot be denied to an accused merely because allegations are serious unless there is a prima facie case, the Punjab and Haryana High Court has observed. Granting bail to a UAPA accused, the court observed that there was no prima facie case for allegedly planning to commit some terrorist acts based on relation with Pakistan. Observing that its duty become more onerous since UAPA has stringent provisions, it reiterated that it is well settled that merely because allegations were serious, on that reason alone bail cannot be denied. Moving on to international news this week. In a big blow to the Rishi Sunak government, the UK Supreme Court has unanimously ruled that the government's proposed policy to send certain asylum seekers to Rwanda while their cases are processed is unlawful. The Supreme Court concurred with the Court of Appeal decision from June this year and said that there were sufficient grounds to believe that refoulement could occur, that is, genuine refugees could be returned to their countries of origin and unsafe circumstances. Migrants with criminal records in Australia will face up to 5 years in prison for breaching their visa conditions under emergency legislation introduced in response to a High Court ruling that a foreigner can't be detained indefinitely as an alternative to deportation. The decision reversed a High Court ruling from 2004 that had allowed stateless people to be held in migrant centres for any length of time in cases where there were no prospects of deporting them from Australia. The decision also undercuts Australia's harsh policies toward asylum seekers who arrive by boat and criminals who are deported despite having long years in Australia. The United Nations top court has ordered the Syrian government to take all measures within its power to prevent torture in a case in which the Netherlands and Canada accused Damascus of a long-year campaign of torturing its own citizens. The interim order is intended to protect potential victims while the case accusing Syria of breaching the Torture Convention proceeds through the International Criminal Court of Justice, a process likely to take years. In the end, we have miscellaneous news. The Supreme Court has refused to entertain a petition seeking a direction to the Centre and others to frame guidelines for regulation of trading and mining of cryptocurrencies. Cryptocurrencies are blockchain-based digital or virtual currencies which operate independently of a central bank. A bench headed by CJ Riva Chandrachud said that the main relief sought in the petition were more of the nature of a legislative concern. The controversial Haryana law mandating 75% reservation for residents of the state in private sector jobs has been struck down by the High Court of Punjab and Haryana, which has termed it as unconstitutional. The Haryana State Employment of the Local Candidates Act, which underwent several changes after it passed in 2020, provided for 75% of private sector jobs with the monthly salary or wages less than Rs 30,000 being reserved for people with a resident of domicile certificate. The domicile requirement had been brought down from 15 years to 5. The Supreme Court has decided to replace the term sex worker in its handbook on gender stereotypes with trafficked victim or survivor, or women engaged in commercial sexual activity, or women forced into commercial sexual exploitation, after a group of anti-trafficking NGOs wrote to Chief Justice D.Y. Chandrachud that using the word sex worker for words like hooker or prostitute may end up promoting another set of gender stereotypes. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.